Criminal procedure and the constitutional rights of U.S. citizens. Although there's no remedy written into the Fourth Amendment, there are three remedial options for individuals that believe they have been subjected to unlawful searches and seizures in violation of the Fourth Amendment. The first one is the exclusionary rule that was born in 1914, and essentially what this says is that the evidence is inadmissible in court if it was gained through an unlawful search or seizure. This has been applied to the states. The purpose is to deter the police, and this can be a very valuable rule for the remedy for the individual whose rights were violated. Having the evidence suppressed can have a significant impact on the case that they are facing. So there are two other remedies. One is a 1983 civil rights action. The problem here is not really valuable, doesn't suppress evidence, doesn't keep people from going to jail, doesn't provide for monetary damages or anything else. And the same thing with the police complaint and other administrative remedies, really not much value to the individual. So the most valuable component here to the individual as a remedy is the exclusionary rule that suppresses evidence that was gained as a result of an unlawful search or seizure. There are at least four exceptions where the evidence that was gained as the result of an unlawful search or seizure is found to be admissible. The first one is the good faith reliance on a warrant. And here the idea is the police had a good faith belief that they had a valid warrant that was later found perhaps to be invalid. And the reliance must be objectively reasonable. So a reasonable person in the shoes of the police officer would have a good faith belief that the warrant was valid. If they had secured the warrant through perjury or recklessness, the police had deliberately had a warrant issued that they knew was invalid, then this does not apply, and the good faith exception is not available to the police in that situation. Also, where the magistrate that issued the warrant did not abandon his duties, the magistrate must also have been working to fulfill his duties in good faith and issued the warrant in good faith. So a warrant that is issued in good faith and that the police have a good faith belief that the warrant is valid, the evidence seized, even though the warrant was later found to be invalid, can be admissible under this exception. Under a similar exception, if the evidence was admitted based on a good faith belief, reliance by the police on the statutes or judicial decisions, then this can be admissible as well and is not automatically excluded. The exclusionary rule applies to the actual trial of the individual. It does not apply to other hearings and evidence that is obtained in violation of the Fourth Amendment through unlawful searches and seizures can be admissible in other hearings, like preliminary hearings, grand jury, probation hearings, parole hearings, sentencing hearings. So this is an exception, an important exception to the exclusionary rule. And in many cases, the information, the evidence that is gained in violation of the Fourth Amendment can be used to impeach the witness, although it cannot be used for the truth in many. It's not admissible for the truth. It can be introduced to prove that the witness is lying. So here are at least four exceptions: good faith reliance on warrant, good faith reliance on statutes, other hearings, and impeachment. An extension of the exclusionary rule is the fruit of the poisonous tree doctrine. And this is intended to deter the police from using illegally obtained evidence or illegal means to obtain evidence. And the idea here is that the tree is the illegal search or seizure, and that the fruit of the illegal search or seizure is then tainted, it is poisonous, and is inadmissible. So this applies to situations, for example, where the police hold gather information from an illegal search that there is evidence they may find a key in the search to a locker, and they then go ahead and under another search the locker, and they find evidence in the locker. Well, if the initial search was in violation of the Fourth Amendment, then the evidence seized in the locker was the fruit of that violation. It was the fruit of the poisonous tree, and that fruit is inadmissible. Not all fruit is inadmissible. Not all this evidence is inadmissible, and it really depends. Obviously, if the fruit does not come from that particular poisonous tree, if it comes from an independent source as well as from the poisonous tree, for example, it can be cleanly obtained from an independent source, then it is admissible. Also, attenuation. If the link between the original illegal, unlawful search seizure and the evidence is broken, perhaps by the individual voluntarily making a subsequent confession, then the fruit of the confession is not considered to be poisoned, and the link is attenuated. So the connection can be broken, and an illegal search seizure does not mean that all the subsequent evidence that is discovered is subsequently excluded and suppressed. Another exception is inevitable discovery. So where, for example, the police interviewing a suspect in a murder, the suspect told the police in violation of his Fourth Amendment rights where the body could be found, but the police had a search squad that was searching the area where the body was ultimately found. The court said that this would have been discovered anyway, and the evidence was not excluded merely on the fact grounds that it was the results of the illegal, unlawful search, seizure, and the unlawful actions of the police. The information would have been discovered anyway through inevitable discovery. In a home arrest situation, where perhaps the arrest in the home was unlawful, when the individual then is taken to the station and there is probable cause for that individual to be arrested, the individual in the station then makes a confession. This is considered to be separate and not fruit of the warrantless home arrest and is admissible. Knock and announce. If the police have a warrant to enter and search a house, a home, and they find evidence in there, but they didn't knock and announce, this is not considered sufficient grounds to exclude the evidence in federal courts and many other courts. So the evidence seized following an unlawful knock and announce search without 20 seconds period between the knock and announce and the police entering is actually admitted, and this is one of the exceptions to the fruit of the poisonous tree doctrine. Criminal procedure and the constitutional rights of U.S. citizens.